The penalty of excommunication for breach of the Constitution must not have done the trick, because in 1357 an Act of Parliament, the 31st Act of Edward III, Chapter 11, was passed, restricting the persons the ordinary could appoint as administrator to those most interested in the intestate's personal property, the next and most lawful friends of the deceased person intestate, and giving the administrator the power to sue and making him liable to be sued in respect of debts in the same way that an executor could be. In 1529, a further Act of Parliament, the 21st Act of Henry VIII, Chapter 5, was passed, further restricting the ordinary's choice of administrator to the widow or next of kin in the intestate. Finally, in 1670, in the reign of Charles II, a statute of distributions was passed by which the ordinary was bound to distribute what was referred to as the surplusage of an intestate estate to the intestate's widow and next of kin in shares and in an order of succession actually set out in the statute. As a result, the ordinary ceased to have any interest in the intestate's estate, and he had become a judicial officer responsible, in addition to his functions in relation to wills and executors, for declaring the intestacy, deciding any dispute between the claimants. Under the statute of distributions, and appointing the person entitled by statute to be appointed, the administrator, effectively the predecessor of the probate court, in 1540 a statute of wills had been passed providing for wills relating to land to be in writing. In 1677 a statute of frauds was passed stating that those wills had to be signed by or on behalf of the testator and properly witnessed. It was also recognised that unwritten wills of personal property could still be made, but limited the circumstances in which they could be made and the way in which they could be proved if they were to be recognised. So specific rules had been made by which the formal validity of a will and its entitlement to be admitted to probate was to be determined in most cases. The Wills Act 1837, as amended, contains the rules which apply to wills made today, if they are to be valid. By the Court of Probate Act 1857, all probate jurisdiction was removed from all ecclesiastical, peculiar, manorial and other courts and persons in England then having jurisdiction or authority and vested in the Court of Probate established by that Act. A principal probate registry was established in London and district probate registries in the provinces. The Judicature Act 1873 united a number of courts, including the Probate Court, as one Supreme Court of the Judicature in England and Wales, and probate business was assigned to the Probate, Divorce and Admiralty Division. By the Land Transfer Act 1897, the court was empowered to grant probate and letters of administration in respect of lands where there were no personal property. Most of the Court of Probate Act 1857 and the Judicature Act 1873 were repealed, and the provisions consolidated in the Supreme Court Act of the Judicature Consolidation Act of 1925. It in its turn has been replaced by the Supreme Court Act of 1981. In 1971, as a result of the Administration of Justice Act 1970, the Probate, Divorce and Admiralty Division became the Family Division. Non-contentious or common form probate, the business of obtaining probate and administration where there is no contention as to the right to it, is now assigned to the Family Division of the High Court of Justice, but contentious probate business is assigned to the Chancery Division of the High Court of Justice. And the sources are Halsby's Laws of England, 4th edition, volume 7, Williams, Mortimer and Son, Executors, Administrators and Probate, 18th edition, Parry, The Law of Succession, the 5th edition, Dyke v. Walford, 1846, 3 more, PC 434, and Hewson v. Shelley, 1914, 2, Chapter 13, which consider statutes and laws going back to Saxon times. Note, statutes and laws, separation. Thank you.